Good morning, dear colleagues. I'm happy to open our roundtable discussion, which covers the problems of judicial discretion and lawmaking in general. There are many opinions on the role of the judge in the legal practice, and there are certain there's a viewpoint that the judge serves other bodies, and his role when passing the judgment is limited in the sense that he has a certain framework and limits, and he cannot go over these limits. On one hand. On the other hand, it contradicts an idea of bridging the gaps in law, applying law and applying laws and acts. Nowadays, we treat it very mildly. So when trying to find the spirit of the legislation, it is still present in the court's practice. We are limited in time, but we have a lot of panelists, and as a moderator, I would like to voice over the format we are going to follow. I bet each speaker would be ready to go on for an hour and a half, because the topic is really urgent. So, but we'll have to stick to the limit. At the same time, we would like to have a dialogue with the audience. In case you have any questions you would like to discuss, or maybe make comments to the presentations, it would be great, and we'll try to secure time for that. We'll first discuss the problem as such. How does a lawmaker treat the judicial discretion, and how should it be treated in general, and its role in the legal system? And we'll discuss the examples, the cases, using several international cases. I would like to dedicate a number of questions to realize what are the limits to the judicial discretion. When the judge is bridging a gap, or when they have a situation with contra legem, when they which used to be unthinkable, but it would be interesting to know how these novelties work in the legal practice, in the court practice. I'm not trying to persuade everyone to use contra legem principle in courts all the time, but we have examples, and you can treat them in a different way. But I would like to know of these examples, and maybe our experts would share their experience. We would also like to pay attention to practice, to actual cases, to the cases reviewed in the Presidium of the Higher Court of Arbitration. And both these ideas of discretion and these actions play an important role in the higher arbitration court. I'm afraid that will be it for today's session, but if we have any time left, there are some questions posed by Mr. Karapetov. Limits of retroactive force within the higher court of arbitration practice. I guess this would be also of great interest, and if we have any time left, I will be happy to discuss it. Our 2 days session, our roundtable discussion, I hope, will not be reduced to presentations and questions. I would like to hear the points from the speakers, and then so the speakers maybe will have a floor several times. And the honor to start the roundtable discussion. The discussion goes to Artyom Karapetov, who would launch the discussion, so to say, warm us up, because he always gets to the core of the problem. Thank you very much. I can warm you up. And I can go on for more than an hour and a half. I'll try to be brief. And well, the topic is of great interest. Our discussion is called the role of judicial discretion. There could be discretion in establishing facts, or certain discretion when applying certain norms. But Andrei Vladimirovich gave a good vector for our discussion. When we use discretion, applying it to facts, while it's obvious. But when we view discretion as participation in lawmaking, this could be a subject of discussion. In general, does court create law? I mean, this discussion has been going on for years, but at present in the Western Europe, there has been a certain consensus on the matter, and I'll try to describe it in general. Well, the first point, court does make law because it should do it. I mean, it's the first reason why it does it. The legislation, which could try to solve all the problems, it has gaps, inevitably. For example, our civil law now covers only 5% of all the issues we face. All other issues need to be solved somehow, resolved. When you don't have a relevant norm in law, then the court cannot decide, cannot pass a judgment. So they are bound to create certain norms and regulations to pass a judgment in a case. They can use analog norms. They can apply general laws, or using bona fide or reasonableness principles. But it's always discretion. Even if you use an analogy of law, I mean analogy, when you have so many laws you could use. In the procedural code, you have provisions for this procedure, but how does the judge decide whether they can use another law? It's not provided for. Well, if a judge does not use it mechanically, he also creates the law. He completes the process started by the lawmakers, by the legislators. So the judge, they might not even want to do it, but they are bound to solve the dispute, resolve the dispute. Looking at the civil law of the European countries, we can see that they had a similar approach. In civil codes of France, for example, they have a lot of provisions for this kind of discretion and the contemporary legal doctrine. French contract law, for example, relies on the court practice. Let's not talk about the case law. I mean, it's a different topic. Let's talk about ad hoc legislation. What happens later on when the judges have to deal with the similar cases? We don't know. I mean, and we can start a separate discussion. but you can see that my statement is that we do have case law and we cannot do without it. But getting back to the lawmaking, it plays a great role in lawmaking. I would recommend a fundamental work by François Génie on civil law, on private law. It is translated into English, and this work has become a fundamental book. It appeared in 1879, and it described how courts create law in the areas where you have gaps in legislation. There can be various terms applied to this process, but the main thing is the idea of how it happens. The second reason why courts have to make laws, even when you have relevant norms, they need to be interpreted. We've had an ongoing discussion. Do we have norms that do not need to be interpreted? With the works of Wittgenstein and Gadamer prove that any norm should and can be interpreted. Any phrase needs to be interpreted to recover its sense. And when you interpret any norm, you have to find its sense and choosing from various interpretations. So you cannot apply them mechanically. You become a co-creator of this norm when you interpret it. Many theorists, law theorists, tried to build up a very a system of law interpretation. You can interpret laws relying on the historical legislator. Once you start saying, well, the legislator wanted to say that, you mean it's your interpretation you use. In Scandinavian countries, you often the courts often go back to the archives, trying to search for the initial sense, for the initial meaning of the norm. We don't use this approach, because if we try to understand what the legislator wanted to say, we'd be in dire straits, and sometimes it's better not to try to understand anything. In other countries, they do go back to the legislator's meanings. New textualism, Antonina Scali, the judge of the higher court in the United States, applies an approach when they try to drive the norm back to the historical period when it was created, and they would interpret it judging from the meaning of words, for example, they had in the end of the 17th century. Sometimes the law, the norm, is interpreted in the sense that, in the way that it complies with the Constitution, for example. There's the third way of interpretation is a pragmatic approach, when the norms are interpreted according to the spirit of the time. In the contemporary, in today's context, those who interpret the law, they try to understand how the law can be interpreted at this very moment, and which means that you use the spirit of the time approach, pragmatic approach. In Germany, it is the most. In Germany, this is the way they interpret the laws most of the time, because the norms, when the laws were created, could have been different, and the higher court of Germany develops their interpretation of private law this way. And you have numerous cases when private law and legislation did change over time, and normative message does change in the course of time, influenced by economical changes. Our arbitration court tend to interpret the laws in pragmatic ways, sometimes applying meanings to these norms, and I find it to be a good way of interpretation. We can use other. No matter what methods you use to interpret, we're still bound to use judicial discretion, and the courts need to be creative in developing the existing norms. And the most urgent question is, what are the limits of this interpretation? Any text, when you choose various meanings of the text, we tend to choose the fairest interpretation. Can the court go further and interpret it contra legem? You know, in all textbooks, you have all the textbooks say that when you go beyond limits, interpreting a norm, you reverse it, you change it, you alter it. The court can simply reverse the norm. And in other countries, it does happen. Higher courts in the Western European countries, sometimes as an exception, when they had to deal with when they had to consider some political issues or legal issues, they found out that sometimes it was necessary to go beyond the normative limits, and consensus was reached after the Second World War between the formalists and the creative lawmakers. Once the the judgment becomes unbearable if you interpret the law in a certain way, but only the higher courts can allow to go beyond the limits once the constitutional values, for example, become more important than the norms of law. In German experience, it's okay. In the German-Iranian practice, there was a case when, with a defamation case, when a princess whose interview in a newspaper was considered to be a defamation, but it did not fall under the norms of the German law, but eventually it was considered to be a legal case. But it's not very often when the high courts would change the meaning of the law, not by using direct contra legem, but using limits in the law interpretation. The Iranian code, for example, had it that when you the deed of gift was considered to be was considered to be part of a contract. The limits in certain cases, the courts tend, and as it happened in the 19th century, tended to limit the norms to the extent when these norms could not be used any longer. And there are many examples. For a higher court, it's a more safe way to reinterpret a norm than to abolish it. In the 20th century, when it became obvious, after 200 years of the private law development in Germany and in France, through lawmaking in courts, it had to be legitimized. And it was done in a very elegant way to make everyone happy. All the channel norms, to introduce the channel norms, as they call it in German law. So the fairness, the bona fide norms were excluded. It was decided to exclude them from the codes. And the French norms, they do have them, but the courts, when they are altering the law, they go through legislation. The legislator gave them an ability to ignore any norm by saying that it leads to the breach of bona fide or reasonableness principle. These norms appeared in these codes before they started to be used in this way. In Germany, they had it in 1900s, while the courts started to apply them only in the 1920s.
There was the well-known story about galloping inflation in Germany when the lawmaker intentionally didn't include in the code the rules about the changes of circumstances, and it was done on purpose because the contract was sacred. And when inflation was millions of percent, the German High Court started changing the contracts because the mark was devalued, and a conflict with a parliament occurred, but the High Court overruled the parliamentary resistance. So it happens a lot. Right now, it's not lawmaking because we're applying the 10th article of the Civil Code in Russia, and it's been happening in Russia during the last 5 years. It's something that was happening in Europe 100 years ago, and right now the 10th article is being applied, sometimes contra legem, over and over again in Russia right now. When the court makes something like that, the court has to understand that it cannot be ad hoc lawmaking. They have to think about the legality of the decision for any analogous cases. It's important for that not to look like that. We decided that to be like that ad hoc, just in this case. No, it can't be like that. It has to be written so as to make everyone understand that in the case when A, B, C, and D are the facts of the matter, it should always be so. Right now, the transparency of the argument is not always preserved. Quite often we see that the decision is correct and just, but its motivation is such that the application of this decision in the future is questionable, because the hypothesis of the legal rule, of the legal norm, is very questionable. There is a resource for future development, for the involvement of the Supreme Court of Arbitration. Looking at this trend, we can see that adding transparency to this process would improve things a lot. Being more attentive to formulating the hypothesis would help a lot. I think we'll reach some kind of a balance and a compromise between the dynamics and stability. One American judge said the right cannot be static, but it cannot be chaotic. So a compromise must be made when the dynamics can counterbalance stability. Let's be looking for that. Was I within limits? No, but that wasn't the main thing. We don't have to be strictly within the set limits. It's important to ask the right questions. Dr. Karapetov touched upon a very important issue, and I wanted that to be heard not from people who work in the Higher Court of Arbitration and who are preparing some basis for their future work, but from a scholar who was publishing articles on that issue. So this is basically a statement of fact. It might be wrong. Let's discuss that. Let's make not a Chinese wall, but maybe a Russian wall, and look at what's happening. If you don't know and you decide, it's not good. It's better to know and to decide with good knowledge. One of the examples which give the courts the right of judicial discretion was the good faith principle in the Article 1 of the Russian Civil Code. So everybody has to act in good faith. We only had the ban on negative behavior, but now we have a positive clause. And there was some kind of the Ministry of the Economic Development wrote a negative report about that. You can look it up. They say we disagree with that. We disagree with the good faith principle being applied in Russian courts because it will lead to judicial activism. That's what they think. And I'm quite happy that the lawmaker didn't agree with that. So we do have Article 1 of the Civil Code that speaks about good faith. So now I would like to give the floor to Dr. Asoskov. The materials of this panel will be published in the magazine and the journal called Law. So I understand, at least in part, what Dr. Asoskov is going to speak about. And I hope that it will be shown that this is some kind of a modern trend. Maybe we'll overcome it in 100 years or so. Maybe it's a pendulum effect. But right now, that's what we see. And there is no reason to think that we're now in the counter trend yet. Thank you. Good morning, dear colleagues. I think Mr. Yegorov was very serious in his selection of speakers, so I'll be also claiming that there is the freedom of judicial discretion in civil law, as was just shown, and I want to speak about the transborder relations with certain foreign agents. Can we exercise judicial discretion in this case? So we're now speaking about international private law, and there are three units of questions. One of them is the question which courts, the courts of which country has to discuss the transborder issues. Second, for example, the seller is in Germany, the buyer is in Russia, the goods are from Finland, from the storage facilities in Finland. So which law will be used? Which material law will govern this dispute? And number three, if a foreign decision was made in Germany, for example, but the assets of the debtor are in Russia, only in Russia. So this is the question of whether we can enforce the court or arbitration decision in Russia. These are subtle questions and delicate questions that are on the border of law and politics, that touch on intergovernmental relations. And up to the beginning of the 20th century, it was thought that international private law is just a technical thing that describe the areas of interest of state courts and applicable law based on the rights of public law and state sovereignty. First of all, understanding which areas this state sovereignty covers was basically the international private law was the projection of that idea onto those relationships. So what kind of discretion can be used here when we speak about very grave things like sovereignty? But at the beginning of the 20th century, international private law was being very actively developed in different countries, and we saw that different countries approached the cases when various disputes could be discussed in those courts differently. And our understanding was that the different states saw these issues differently, and it doesn't breach the rules of international public law, and it cannot be considered a violation of state sovereignty. So by mid-20th century, it was understood abroad that those specific issues of international private law were the issues where the same questions, the same issues as in civil law have to be discussed. We cannot forget about the public interest. So now we understand that this is an important area. The rules of international private law are not just technical. This is an important tool in the hands of a government, because changing the rules of applicability, changing the jurisdiction, we can influence these relations. We can stimulate some participants and hinder some others. So how do we define the issues concerning the legal status of a certain agent? We can use the principle of formal reparation when we look at just the registration, the actual residence status, or we can understand this gives us a certain degree of certainty, that it gives the participants the right to choose jurisdiction and the corporate law that they prefer. But there is a danger in that. The danger for other participants, for creditors, for debtors, and so on. And sometimes you can use the actual place where the company is managed can be used as the jurisdiction for the case. So as soon as we understand that there is some freedom for the legislator, first and foremost, we immediately understand that since this is private law, the legislator cannot take into account all the variability and all the richness of such relations. So the courts must have the possibility to decide such issues in certain cases. Each of these three units that are listed, if we look at them attentively, we'll see many examples of appearance a very serious degree of judicial discretion. For example, international accountability. If we take the Anglo-Saxon tradition, you'll see that the input requirements are very low. Anglo-Saxon courts are ready, in many cases, to review a dispute. But then a specific concept of inconvenience is applied. The court can decide that a more convenient court can be assigned this case. In our procedural code, Article 247, we'll see a number of very rigid directions, which means that the Russian court has to review a certain dispute. But then there is point 10, which says that if there is another bond with the Russian Federation, the Russian court can also take this issue into consideration. So every time when the legislator says that we're speaking about the tightest bond, the tightest relationship, and the students who study the private international law are asking themselves, what is that? The internal meaning of this formula is simple. Thing is, the legislator says it's difficult for me to rule on this. I can't say a priori which jurisdiction or which law should be applicable in this case, and I'm giving that to the discretion of the court. the courts, basing their decision on the circumstances of a certain case, will make a decision. If we look at our law, in contract law, if the parties have not chosen the law, then the law can apply that. But it also says that other discretion can be used, and so this is a qualification, which means that the court in a specific situation can go from the presumption explicitly stated in the law and switch on to a different jurisdiction. This is judicial discretion. In international arbitration, this discretion is even broader. In the rules of the London Arbitration Court, the International Trade Chamber, the Stockholm rules, we will see that if the parties have not chosen the jurisdiction, the arbitrator chooses it, and many lawyers are surprised by that rule, by the clause. The arbitration uses the rules that the arbitration court considers convenient. So they basically choose any laws. They don't even have to base that in the rules of international private law. It doesn't have to be the rules of certain national private law. It can be the principle of unit right, it can be international. And finally, the enforcement. We all know that one of the universal rules for that is the contradiction with public policy, and no legislator has yet given the definition of public policy. Now, reform of arbitration courts is being discussed, and we're speaking about the definition of public order or public policy. But this is kind of strange, and we see that we cannot move away from a certain degree of judicial discretion. So basically, I just wanted to confirm what Mr. Karapetov said, but in a different area in international private law. Thank you. Before switching to our next block of questions, I want to ask the speakers, would they want to add something in the context of what's been said, or we can say that we live in a situation when there is a certain degree of judicial discretion, and now we can discuss what kind of discretion we're speaking about. I just forgot to say one thing, that apart from certain evaluation regulations, there are certain tools. If you look at the second part of the civil code, you'll see the phrase, if it does not follow from the essence of the relations. And this is something that the judge can overrule if he thinks that out of some value or other important issues, this doesn't hold. So the more another tool in Dutch civil code, there is a wonderful thing. There is number 6, I don't remember which exactly. The court cannot use any rule of this code in the contracts if it leads to injustice or unreasonableness. So this is full legitimation. And another tool is the turning of every rule into some basic words, trying not to legitimize every small detail. So what we're talking about right now, I'm not sure that this approach could be justified in public law. What kind of chaos could arise from that if you listen to that? We're speaking about the judge's discretion in everything. Wouldn't it be chaotic? I want everyone to keep in mind that the common law is the decision, is the solution. If there is no Supreme Court that rights, information letters, and so on, unifying the legal field. So if we buy that, we have to buy the other thing, or just live with that. We're not for chaos. Thank you.
Thank you very much, dear colleagues. I would like to get to our second part of our discussion, and on my own behalf, I would love to give you several cases from the Higher Court of Arbitration. Mr. Garapetov is, trying to get to the contra legem problem. It's a very complex problem, and there are cases both in Russia and abroad. And if I give you examples, I will probably be able to explain why the court would use contra legem principle. In my understanding, I've read it, I don't remember where, about the German, how the German lawyers see the law evolving. When the legislator drafts a law, they cannot foresee everything that will happen in the future. There can be cases when these laws will be unfair. Later, the court practice either applies this law like in a common law manner, like case law. Like in England, they had carts and the carriages, and later they had cars, and they could either apply the existing laws or create new precedents. But if this court practice bridges this gap, not the way it pleases. The judges are people selected by the society. If we're speaking of the higher courts, they're people who have been entrusted by the society to solve these problems, and they decide how to bridge this gap. After that, the legislator may agree to this change or disagree with it. So they help the court to solve this problem. In case they don't agree, they would include their provisions, their new solutions. Or if they don't, sometimes the legislator would agree with the court. For example, I deal with bankruptcy a lot, and there are many examples when they have explanation of the high arbitration court, and then later it is included into the bankruptcy law. You can check it. But there are certain cases where the law would disagree with the court, the legislators would disagree with the court. It doesn't mean the court should be offended. We do our job, the court, and the legislators do theirs. Well, just to give you a case, speaking of the damages within an article when they make thank you, an article costs more than it used to cost before the repair. I had a case in 2010 when there was a question whether the court could ask for information from the telecom providers about their subscribers, like their address, and two laws were in conflict. The law on personal data and another law which allowed to ask for this information, and the higher court said that no, you can't demand the information, and later there were amendments made into legislation. Once the gap was found, it was later breached, and this is the kind of work we should do in a civilized way. And after this short introduction, just to give you examples how it works, I would like to give the floor for a short presentation because, I mean, we're having less and less time. But I would like to ask my colleague to show and to tell us more about the freedom of judicial discretion, to ask Alexander Vereshchagin to elaborate. Thank you, Andrei. All the forms of interpretation that exist in the theory of law and in legal practice, you know, you have logical, ideological interpretation, historical interpretation, but not a single developed legal system knows a hierarchy, a system to interpret. Sometimes it's vague. You don't know in what order should the law resolve to various ways of interpretation. Should they start with the word for word, with the literal interpretation? This is how they should start interpreting a law, but it is not formally prescribed. So if the literal interpretation does not help the court, what ways of interpretation should they apply? We have an informal doctrine for courts, and I would like to emphasize the following. Judicial discretion exists in different forms, and like I've said, it could be a choice of the ways of interpretation. Court has a right of choice, and it's also a discretion in its own way. Another very important aspect, when we talk about judicial discretion, we, as a rule, think that case law is a manifestation of judicial discretion, and but in fact the relationship between judicial discretion and case law is more complex. A case or a precedent is one of the ways to limit judicial discretion, because once a court passed a decision considering various circumstances, it means that next time they should pass the same decision given the same circumstances. In this sense, precedent or case law limits judicial discretion, and they can even be in conflict. In Russia, as we all know, judicial lawmaking is often viewed or masked as judicial interpretation. But once you have a right to interpret norms, the court often can go rather far. Judicial interpretation, creative interpretation, has a long-going tradition in Russia. The Senate of the Russian Empire was a body that created many legal institutions, Russian legal institutions, from the scratch. Legal interpretation or judicial interpretation in the Russian legal system can exist in a form, in two forms. It's either the court makes decisions in actual cases or as abstract explanations. Russian law, in this sense, is rather unique because it provides a wide opportunities for the courts, a lot of forms that the courts can use to interpret law. There is this abstract interpretation, which is a unique phenomenon. I mean, information letters, memorandum, various reviews from the higher courts that are sent to lower courts. And this is the way the higher court would interpret law and prescribes the same kind of interpretation for the lower courts. And we end up with a paradox when, on one hand, Russian law traditionally is very careful about judicial lawmaking. On the other hand, it gives more opportunities for the courts in this sense than other legal systems. Like in England, you don't have this wide number of choices to interpret law and to recreate it when you have gaps. At the same time, to my opinion, and you might not agree with me, there's a number of forms for creative interpretation is too wide in the Russian law. For example, one doesn't understand why do you need those information letters from the Higher Court of Arbitration. Those information letters are so-called letters of recommendation, but in fact they are obligatory for lower courts because the Higher Court of Arbitration will check whether the courts follow these recommendations. At the same time, the Higher Court of Arbitration, as you know, it exists as a presidium of the Higher Court of Arbitration, which adopts these letters. And there's a plenary session of the Higher Court of Arbitration, and it's very difficult to decide whether a certain issue for interpretation under which authority does it fall? Under the authority of the presidium or under the plenary session? I guess we all agree that this interpretation is often creative. It doesn't mean that every norm in this information letter from the Higher Court of Arbitration, we don't understand how this practice complies with the division, with the separation of of powers. It's a body, the Higher Court of Arbitration is a body which provides legislation, but I mean it's a secret, hidden legislation. If you allow me later, I would love to discuss this matter with members of the Higher Court of Arbitration. Thank you. Well, the question must be answered fast. I mean, it's a law of modern economy. I don't know the answer to this question, but I will allow myself to suggest that these norms of interpretation, for interpretation, have a right to exist. I think that Mr. Karapetov has shown us that legislator often understands that they cannot foresee a model for any similar case. They understand that there can be different modes of behavior, and they can differ so much that it will change the nature of legal practice. In our civil code, we have norms that provide room for assessment. Higher courts, when they interpret law, when they analyze the practice, they're very close to legislators. In some cases, they're sure that the norm should always be interpreted in one and the same way. In these cases, this interpretation becomes less flexible. After the plenary session adopts a certain act, this norm becomes part of the law. In other cases, we apply more flexible ways of recommendations because then we show different cases and suggest certain reasonable.
Тогда судья здесь более свободен, он может учитывать какие-то особенности, обстоятельства этого дела. И вот это позволяет более гибко подходить к толкованию права. Также, в общем, как мы видим, и
Since I have occupied the mic, and I would also like to point out another aspect. The fourth speaker is using the phrase "court interprets," "court makes law." Some say it's good. Others say the others who say it's not good, they're not here. But I would like to we. I would like to tell you about a very different aspect. Let's take a case. You have a rent agreement when you rent a car, and you have to return the car after you've rented it. And the claimant says, I needed to have it returned. And the defendant says, no, he had to take it himself. And the judge opens the code, and there's nothing about it. And he asks the claimant, why do you think he had to return it to you? There's nothing about it in the contract. And the claimant says, well, honored judge, I mean, you all understand. My grandmother always said, put it back where you took it. So he had to return this car to me. And the judge thinks, well, maybe it's reasonable. And my granny also told me to put things back where they belong. And maybe all grannies think this way, and grannies are wise, and they might be right. So that's why I tell the defendant to give the car back. Of course, it's a joke, but it's not the grannies who form the lawmaking. But they say, well, the court is interpreting. It is not always true, because the court has to deal with the parties, the claimants, the defendants. They provide evidence to interpret the norm this or that way. And the judge has to weigh the arguments. He assesses his risks. This is how he should act, and only after that he would pass the judgment. And if I'm right, maybe we should say that in interpretation of law involves not only the courts but also the people. The lawyers defend their clients, trying to get benefits. They have conflicts of interest, and the judge decides which party is right. Well, sometimes the decisions are more complex, but the general model is like that. And what we have, I mean, we have that in the law, in vague areas, the law is developed not by the court. It channels this idea from the people, and it's a very democratic way and a very fair way of this is how it should be, and that's when people will be content, because it is done for them, but by the experts, by professional attorneys, by professional judges. And in this context, it's not so obvious that a court or a higher court would create norms. No, it is done by the expert community, and this is how it should be done. Because there's a legislator who stands above the higher court. You also have other judicial structures, constitutional court, higher court, with many courts in society. They influence each other, because even the higher court of arbitration always has to look up to the higher court, and they have to check whether constitutional court had something to say about it. And it works like a balance of checks and balances. And if it works like that, we'll have fewer risks in judicial interpretation.
Thank you. I wanted to add a few words. Whether the information letters are obsolete. I think the practice of the higher arbitration court is something that shows that those information letters are just a recommendation. I don't know of cases where a judge would be punished for non-compliance with what was contained in the information letter. At the same time, the idea of the information letter is a thing in itself. There are certain things that cannot be decided on a meeting. We can discuss things like interpret certain things, but any evaluative thing can only be discussed in review. We have the plenum for the defense of eternal rights, a bona fide purchaser, and so on and so forth. So you cannot vindication is not used or has to be used if the possession is lost. So we can acknowledge the right and so on, real estate. It's an abstract thing, but whether you can't say whether you was a bona fide purchaser or not unless it's the review of practice. When something was quickly sold and bought in a series of transactions, it looks suspicious, or maybe the price was too low and so on. That cannot be discussed at the plenum. So I think the genre of information letters has the right to exist. You cannot decide all things at a convention. I think the higher arbitration court is handicapped because we don't have the anything apart from the convention decisions. We don't have documents that say about the specifics of the applicability of certain rules. The courts are in the same situation. I've been reviewing that practice. They just use this formula. So this is a kind of a status quo situation. It's not quite clear. If a review existed, that would be very convenient. So in that sense, I think the genre is not dead yet. So now I would like to give the floor to our German colleague, the partner in the NOR-LP law firm from Frankfurt on Main, who will tell us about the German practice and about her experience of a practicing lawyer. And perhaps she would be able to tell you, guys, what you read in those textbooks in life, it's not like that at all. Or maybe she would confirm what was said, so we'll listen to that with interest.
Thank you very much. First, I have to ask for your forgiveness that I'm holding this presentation in English. If I was to speak in Russian, it would be very short and end after the word Dobry dzień. So we will go ahead by I will speak slowly, so hopefully everyone can get it. Well, in German practice, judicial discretion has a very important role. And it is a very important part of the legal system because the legislator knows that you have to have a certain dynamic in the law. You cannot make rules for all circumstances. Moreover, the judge has to apply the abstract rules on an individual case, and that always requires applying a certain amount of discretion. We have oh, sorry, it was a little bit slow. We have procedural discretion, but I will not talk about that. That is more about how a judge can conduct a civil case, how he wants to hear witnesses and how to weigh witness testimony and so on. I want to focus more on what is in the law and what discretion does the law allow for judges. And there are basically two different sets. The first is that the judge has discretion with regard to the elements of a rule of law. The elements are undefined terms or very general words that need to be interpreted, and the content and scope of the legal term cannot simply be conducted from the wording, but requires interpretation. The second scenario is that the legal consequences of a statutory provision requires the discretion of the judge. There, the judge specifically has the task to find the outcome of a certain provision. When we turn to the first, where we have undefined legal terms or general words in a provision, the judges have to interpret these words by the established means of interpretation. First, the judge would look at the wording, but if the wording does not help, you would look at the systematic structure of the provision and the purpose, what was the intent when these provisions were made, and also the history, how was this provision applied in the past. Now, is this interpretation very broad and without any limits? No, it is not. The Court of Appeal that would hear the case in the second instance can review how the first judge has made the interpretation. And if the second court, the Court of Appeals, finds that the interpretation was not correct, the Court of Appeal can revise the ruling. I have brought two examples, excerpts from German textbook, which point to rules where we have those general words that require interpretation. One example is a section where it says that a legal transaction is invalid if it is contrary to public policy. Now, the judges have to determine what exactly constitutes public policy. It is a very broad and general word, and you have to fill this word basically with life. The next example is a section that is very famous, and actually German law students have a lot of respect when dealing with this clause, because it says that if you enter into a contract, you have to perform your duties in accordance with good faith principles. And good faith is, again, such a broad word that you don't know what exactly is good faith. And it depends very much on the individual circumstances. Now, the other scenario is that the legal consequences of a rule are uncertain and require for the judge's discretion. And you can find and locate these types of rules from a specific wording. For example, the code will say, if these and these criteria are met, the judge may, or may within reasonable discretion, do this and that. And in those cases, the judge has to exercise judicial discretion, but not without any limits, but on an objective basis. And there is a certain scope that a judge never can exceed. Otherwise, the second Court of Appeal will revise the decision. For example, the judges have to treat the parties equally, and they have only the ability to award proportionate decisions. So if those limits are exceeded, it is very likely that the second court of instance, the Court of Appeal, will reverse this decision. Again, I brought an example of one provision, and that says when the contract is structured in a way that one party has to specify how to perform the contract. For example, one party has the right to set the price for goods. And if this party does not make an equitable specification, then the judge has discretion to make this determination on behalf of the parties. And it says the specification is made by judicial discretion, and so it is explicitly in the law that the judge has to step in and come to a ruling. Now, of course, these forms of discretion are made to allow flexibility and to adjust to circumstances that may change over the time. And I brought one very interesting example with me, and that relates to the sale of a law firm. If a lawyer wants to sell his business, until, I would say 60 years ago, this was not possible because the German court said the sale of a law firm generally violates public policy because the lawyer does not run a business, the lawyer has a duty only to the law, and it is not possible to simply sell the law firm. In that decision, the former Supreme Court in 1936 said that it is really about the trust between a lawyer and a client, and this is not part of a sales contract. That's impossible. Approximately 30 years later, this decision was changed by the highest German federal court in civil matters, and the court said it is possible to sell a law firm, and that does not violate public policy because, of course, a lawyer has a duty to the law, but also he has to earn a living, and this is also an essential part of the legal business. Now, if the lawyer who wants to sell his business recommends that the clients move on to the purchaser of his business, that can be a monetary value for the purchaser, and this is then the purchase price of the law firm. And most recently, in 1995, this was confirmed. However, the judges went then on into further details. They said, yes, it is possible to sell a law firm, but we want to protect the clients, and we require the prior consent of the clients, and if the clients do not consent to a transfer to a new lawyer, it is not possible to sell the law firm. So this example demonstrates very nicely that the judges shifted in their assessment, and after they said in 1965 that you can sell a law firm, the most recent decision in this area said moved on even further and said, yes, that's correct, but we want to be more precise and now protect the clients, and so really define the case law even more. And this brings me to the end of this little presentation, and I look forward to discussing with you if it is beneficial to have this flexibility or not.
Thank you very much, Mrs. Meyer. I think the journalists present at our panel will have to write the following. If you had a grandmother, you have to know what good faith is. I'm trying to join what Sergei said with what the esteemed Dr. Meyer said. We are running out of time, so right now I would like to give the floor to two speakers, of course consecutively. So please keep within 5 minutes limit, because we have to leave 5 minutes for summing up and maybe say a couple of words about contra legem. So right now I would like to give the floor to Vyacheslav Gorbachev, who is the partner in the company Khrenov and Partners.
Thank you very much. I would like to thank my colleagues, since their presentation would allow me to stick to the 5-minute rule. Much right things were said regarding the existence of the Russian legal systems, use of discretion, fairness. Much has been said regarding of the application of the Article 210 in the Civil Code of the Russian Federation. Is expanding in time, and I would like to draw your attention to two trends which are quite noticed by the practitioners. First thing, we are trying to specify the things that are known for the Russian legal system, I mean the Article 110, or in the Supreme Court practice, which got quite a specific and direct application. And I would like also to note a new evolving trend, which is the intervention in the court decision, I mean the Supreme Court in the first place. This is the overwhelming trend, and this is the disclosure of the corporate units with which our legal firm faced or confronted with. It was last April 2012, and Supreme Court, while considering the competence of the Russian Arbitration Court, applied this concept, which frankly was a bit of surprise for our lawyers who presented foreign banks, and he said that the participation of lawyers as the third parties and the representative of the foreign banks is the demonstration of the availability of presence in the territory of the Russian Federation, and actually their operation in the territory of the Russian Federation for the purposes of qualification of their presence in the territory of the country from a point of view of a possibility to consider these disputes by the local Russian courts. The first thing I would like to note is that in this particular case, that the application of these rules is a new thing, and we should be quite cautious in applying this. The application of this principle, which is the disclosure of the corporate files, as we call it, like in many countries where it's been in existence for already several years. So we don't have grounds to apply this, and I would like to hope that while applying the same concept in our future judiciary practice, we will manage to establish some criteria for applications. The lower courts, while applying this complex doctrine or concept, are risking at providing quite fusing interpretation for the application of these rules. Thank you. Thank you very much, and I would like to give the floor to Mr. Majdanikov, Vice President of the Rosneft. Good morning, dear colleagues. I'll try to be even briefer, but because all presenters referred to the judicial discretion while applying the Article 110 of the Civil Code, everyone knows the content of this article, and I believe this is quite a general rule, and it's quite evident, or it's hard to imagine that someone is trying to invent some qualifying principles while violating this rule of discretion. Well, I'm saying this because I represent the huge joint stock company, public company, and sometimes quite often we face the violation of good faith principles by the minority stockholders. So the dogma prevails that shareholders are the weakest chain in relations between the management of the companies and the shareholders, but quite often the practice shows that often shareholders violates their good faith rights, violates it, and the judiciary system allows to qualify the actions of the minority shareholders in these processes. Sometimes courts are confronted with a difficult situation because the nature of shareholders is different. Quite good example, when there is a hostile takeover, for example, it's very easy for the court to qualify the actions of the shareholders. I will try to cite some examples from my own practice. You know about the dragon conflict in 10 KBP between two big group of shareholders, and everyone knows about the lawsuit by Mr. Prokhorev. Court failed to establish this, but that was the claim of one shareholder against the other, in the interest of the public. And once parties agreed to sell their stocks in Rosneft company, the minority shareholders sent a letter with a rejection of this claim. Rosneft has always maintained its position that minority shareholders violated their rights, and the Supreme Court nulled the decision of the Court of Appeal. And now this case is sent for the further consideration in terms of to determine the rights of the minority shareholders in this case. A more complex situation is the lawsuits for disclosure of information. What kind of misbehavior can we say about this? For example, the minority shareholder, Mr. Navalny, which requests or claims the provision of a huge amount of documents from Rosneft company in order to set up a register of bona fide or good faith shareholders. It's a very strange way of putting this question, but many courts rejected to satisfy his claim, and they qualify this as the violation of his own right. And summing up, I would like to express the idea that the judicial discretion in any way should be transformed into a certain legal practice or case, maybe law. And we as practitioners would welcome such an approach, but still I also would like to say that the judiciary discretion should be subject to some general trends. Otherwise, we're risking at getting some chaotic situation and getting quite confused court decisions. Thank you. Thank you very much, Igor Vladimirovich, for your presentation. I would rather support your appeal, your urge. Legal practice, legislation, and there's another important area which is called science, legal sciences, which should provide some benchmarking. So two parties involved in the court litigations, judge is listening to both sides, and he at the same time needs to look how it is considered in the doctrinal sciences, the different options of the interpretation of these things. So we shouldn't forget about sciences. We should be involved in this, and we shouldn't hope that Court of Arbitration can provide everything in terms of consideration of these things. Of course, it would be very good to get quite a profound analysis of all these cases, and it would be a good idea to use all this already. And scientists are called to help us address these issues in order to avoid the judges or judicial discretion goes out of the control. So these are correct things to discuss. So the remaining question that we need to discuss is the position of controlegi. I intentionally raised this issue so that you don't have an impression that we are trying to avoid this topic, and we are not urging the courts to apply controlegi provision. There should be a situation, maybe someone from the audience should stand up and raise this topic, saying that indeed there is such a problem. Since it's not the case, then it's up to us to start discussing these issues. Maybe some examples. So, Court of Arbitration sometimes is blamed for having an urge to raise this issue on a constant manner, but sometimes we're trying to protect our position, saying that there is no any indication in the law regarding this rule, and the Supreme Court can agree to this only in the situation when the situation is getting worse and worse. And the law on bankruptcy was drafted in the first draft. Of course, no one noticed this, and it says that court, a general rule, when you appeal a decision or court ruling, you should submit the documentation regarding this. So it says, if you appeal a ruling, then you need to provide the documents to the other party, not to the court of appeal, but to the creditors. So it's very difficult to confuse the court and creditors. Of course, we can send these documents to creditors, but since it is a law, then okay, we decided not to apply this provision. Or there is no provision to recognize the decision, but the law on bankruptcy provided for such a possibility to regard it as void these relations between creditors and other parties. So there are some examples, and if someone indicates that there are some other provisions governing this, it's not so. If it is a case, then we are talking about the presidium of the Supreme Court. Such an example, the rejection of the managers by the Supreme Court on their own initiative. It was very complex things, and the Resolution 35 in 2012 of the Supreme Court, it said that court can reject the manager if it's quite clear that he's acting not in the good faith or trying to just to grab some money from the funds. But if such a decision is made, then it is believed that in all countries, be it United States or European countries, the courts are granted with such possibilities. And we need to protect the bona fide or good faith behavior of those involved in these processes. Of course, there are risks that courts are subject to this rule quite often, but we understand this problem and we try to discuss this with the public, and public should be aware of that. It is done in a scrupulous manner. But I don't preclude the possibilities of some mistakes, and the civil society should be vigilant with regard to that and trying to raise these issues before the legislators. If our speakers are prepared, then let's have 5 more minutes and to listen to their argumentation. Artem Yurich, frankly speaking, while developing this topic, I would like to raise quite a fundamental issue. Sergei Vasilyevich said that the court, in the spirit of Mr. Savini, in the course of emanation, trying to establish its ruling in its practice. But Court of Arbitration and other courts of the foreign countries sometimes perform missionary objectives. They try to drag forward the law, and now the Court of Administration is a driving force in terms of development of the law or private law. And there is, and the locomotive just loses or has lost the carriages it is dragging. And if it's not for the Court of Administration, then we should forget about the private law. But there is another element which is very important. Court of Court of Appeal sometimes produces quite innovative things, and people sometimes are not in a position to assess the principles of the case law, foreign law, or some shortcomings or weak points in our court or judicial practice. And sometimes these innovations are very important, especially if we are talking about the control legi, when we fail the expectations of the people. So this trends is dependent on the evolving things which appear every year in our judicial practice. But against these changes, we just see the changes in the retrospective picture. It's a very important issue. Retrospective, judicial retrospectiveness, when a new position are the grounds to reconsider the decisions made by the lower courts. But another important issue is material retrospectiveness. When you have a lot of resolutions, decisions by the Presidium, and these new legal decisions are applied to the old decisions which were made by the courts. So it means the change in the judicial or legal practice, and we are told that new principles, new positions are already applied. And if you expect that the older positions or older decisions are to be applied, then sorry. So, and there is a problem. We need to predict this, and in foreign legal practice is mainly retrospective. And the legal positions in Germany, they are based on the earlier made decisions. There are some exclusions, like in the legal practice in the United States, progressive or perspective change of the previous legal practice. Retrospectiveness should be kept, maintained, but we need to have a possibility when Supreme Court can rule that this applies only for the future. Can I interrupt, or can I add something? At least we are trying to work out the same position in the Supreme Court. I mean, the resolution of the plenum of the Supreme Court says that a court can establish in the legal position of the plenum the time limits for the application of this rule. But so far your court, the Supreme Court, hasn't applied this rule. Like the lease of a part of a roof is not the name contract. Everyone was happy just to start using this contract, and all rules regarding a lease applied to these previously concluded contracts, and all those were disappointed regarding their expectations because they hope for the ruling of the Supreme Court. That is why I would like that we discuss this issue quite often. In European countries, the majority of the Supreme Courts do not apply these rules, but this is an issue which we apply in our quickly developing, quickly evolving legal practice. Artyom Georgievich just built a very good, solid bridge to the next forum 2014, especially what he said using brilliant examples, and that would be quite a wonderful option to conclude these sessions, and I do hope that we will discuss this topic next year. The next forum, I would like to thank all the presenters for their presentations and quite attentive audience. From my point of view, what I would like to get from this session, I believe we will manage to fulfill our task for 85%. And let's break for coffee, and maybe Artyom Grigorievich will tell you about the emanating things. Thank you.